President Case 24 CR 1250, State of Ohio versus Artur Packus. We're here on a motion to terminate community control sanctions that the state has filed. Scheduled for a probable cause hearing. Defendant's present in court. He's with his attorney, Mr. Brad Wolf. Mr. Wolf, what's the defendant's intention at this time regarding the hearings?
Thank you, Your Honor. Good morning. Your Honor, we would waive probable cause and ask to proceed to the final determination sentence.
Well, you have a right to a final hearing as well. Are you waiving that as well?
Yes, Your Honor. I apologize. We ask to waive that and proceed to sentencing.
Thank you. Mr. Packus, you have been charged with violating the conditions of your community control sanctions. Specifically, it's alleged you violated Rule 11. Rule 11 requires you to comply with all special conditions that are set forth by the court. And specifically, it was ordered by this court, special condition number 2, that during the last 30 days of your incarceration, that you enter and successfully complete the jail treatment program and follow all their aftercare recommendations, including any recommendations that may be made for AA meetings. And it's alleged that you failed to successfully complete the jail treatment program. Now, you have the right to have a couple hearings regarding this alleged violation. You can have what's called a probable cause hearing, which is a hearing where the state would be required to present some evidence that would suggest you probably committed this violation. Then you have a right to have a final hearing on the merits, and that would be on another day and time to give you time to prepare with your lawyer if that's what you wanted to do. Now, you could have either or both of these hearings, but you can also waive both hearings and plead guilty to the violation. And your attorney has indicated, as he just said, that he believes that's what you want to do. Is that correct?
Yes, sir.
Well, before I can accept your waiver, I need to make sure you understand the potential penalties you face if you're found to have violated your community control sanctions. If, in fact, that did occur, the court could extend your probation up to a total of 5 years. It was originally 2 years, so I could extend it another 3 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I send you to prison, it could be anywhere between 6 to 18 months on count 1, the attempted abduction charge. Do you understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have either of these hearings, or do you want to waive both hearings and plead guilty to the violation?
Plead guilty.
Very well. As to the allegation that you violated Rule 11, Special Condition 2, by not successfully completing the jail treatment program, what is your plea to that?
Guilty.
Court will accept your plea of guilty, find that you did violate your community control sanctions. Mr. Wolf, any reason not to proceed to sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Judge.
Go ahead.
I have some comments, then if it pleases the court, Mr. Packus' sister would ask to address the court.
Sure.
And then Mr. Packus would like to. Your Honor, this is Artur Packus. He's 26 years old. Your Honor previously gave him in some 60 days of jail as a term of his term of community control sanctions, and of that to complete the JTP. This happened on April 11th. We are not denying the facts, Your Honor. He was asked to move a towel from a vent. Regardless of the circumstances, he didn't do it immediately. That led to a total of 4 days being in solitary confinement, or lockdown rather. And because he was in lockdown, he wasn't able to finish JTP. It wasn't his intent to not finish JTP, but he fully recognizes the ripple effect that his decision-making caused in prohibiting from completing JTP. He has served an additional 10 days from the date he was supposed to be released to today's hearing. I'm asking the court to not impose any jail time, continue the community control sanctions in light of the fact that he's done 10 additional days of jail, despite the fact he was ordered to complete JTP. If the court was inclined to impose additional jail time or have him complete JTP, I would simply ask that he be given credit for the JTP he's completed, if that's possible. Otherwise, Your Honor, I expect Artur to submit full responsibility for his conduct in this case. Happy to answer any questions. He has a lot of responsibilities on the outside with respect to mortgages and working and taking care of his family, as you'll hear. But I I expect him to convey he appreciates the seriousness of this, Your Honor. So, thank you.
Would you want to hear from a family member at this time?
Yep. Yes, Your Honor.
Well, yeah, you can state your full name, please. Spell your last name for the court report and say whatever you'd like me to know.
Good morning. My name is Ola Komarnitska.
Can you spell your last name?
Yes, Komarnytska.
Thank you.
I'm his sister, and it's been a very difficult time for all of us since he was in jail so many days and months. And at this point, we guarantee that if he will be released, he will successfully finish all his courses that he is required, including AA meetings and so on. But we want him to be home because we know that this situation is affecting his mental health and his medical conditions, and we just didn't want him to become, sorry,
Take your time.
We just don't want him to stuck in a jail or, God forbid, prison, and not be able to live his normal life and come back to us.
Thank you very much. Mr. Packus, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
Your Honor, if I may, one quick factoid I just wanted to add. Although he may have initially denied accountability for this incident in the jail, he did end up signing a piece of paper in the jail in which he changed his plea to guilty for this incident. I'm using air quotes with the word guilty. It was what the jail said for accountability purposes, but nonetheless, Your Honor.
Yes, Your Honor. I'm taking full responsibility for what I done, and there wasn't really a good action for me to do so, and I'm really sorry for my actions, for what I done. I didn't think of the circumstances could be from not moving so fast, for not taking the towel right away after the officer told me to do so, and I really miss my family. I really want you to give me a chance, and
I gave you a chance. You were over in the jail in the JTP program instead of in Mansfield in the prison. You got a chance.
I almost finished the JTP. I had 9 days. I was in the finish line, and I wanted to complete the program. I always obey all the rules, never give a hard time to anyone, and I just really taking all the responsibility for what I done and my actions. And I'm really sorry for it, Your Honor.
Anything else you want to say? You don't have to. I just want to make sure you said everything you said. Want to say?
Yeah.
Thank you. Mr. Wolf, anything else on behalf of the defendant?
Nothing further, Your Honor.
Thank you. You be seated, please. This court reviewed the pre-sentence report and investigation that was originally completed in this matter. I consider the facts and circumstances of the underlying offense that brought us here to begin with. The nature of the probation violation. I've considered everything that's been said here today by Mr. Wolf, the defendant's sister, correct?
Yes.
Sister. The defendant himself. This is all considered by the court in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. So the factors in 2912. I'm going to incorporate all the findings I made regarding the seriousness factors and the recidivism factors with the additional finding today that the defendant has failed to comply with the previously imposed sanctions ordered by this court, which is an indication that recidivism is more likely, and the nature of this violation is just not following rules. Same thing he did when he was on bond, so that's just continuing. I was told that wasn't going to happen, but it's happening. That's an indication recidivism is more likely. You know, Mr. Packus, you come in here and try to portray yourself as just some innocent kid that's doing the best he can and following all the rules and taking responsibility. And that's not what you do. You didn't do that when you were on bond. You play games and you You play games and try to get away with what you can get away with. And then when you're confronted and you're shown what the facts are, then you admit a little bit and you admit a little bit until you finally realize that they know everything. That's what happened when you were on bond, and that's what is happening here. Your lawyer talks about how you finally admitted to it. Well, yeah, you admitted to it at this hearing, but you initially, the initial violation was a minor violation. You didn't react quick enough. That's not what led to a 4-day lockdown. It's the conduct that occurred right after that with them. And your disrespect for the officers at that point. You do what they say, nothing happens. You take it down. If you didn't take it down immediately when they came back in there, you'd probably been locked down for 23 hours. But it's the behavior afterward and denying things that you did and being disrespectful. That's what led to a 4-day lockdown. You don't get a 4-day lockdown for having your towel on the vent and not removing it. It was more than that here, that 4-day lockdown. And you know that. You don't think we know that stuff. So you don't admit to stuff. And then when you find out we do know that, and all of a sudden you start admitting more. Just like we had in the bond situation when we were here for sentencing. Now, you were ordered to complete the jail treatment program. You didn't complete the jail treatment program. Tell me why I would let you out of jail before you complete a program that you were supposed to complete the first time and reward you for violating your probation and not doing what you're supposed to do. Does that make any sense?
No, Your Honor.
Yeah, there's two choices here. You're going to go back in jail and complete that program, and you complete it from the beginning. You can't pick it up where you started. That's not how it works. They don't do that. You're going to do that, or you're going to go to prison. And that's what I have to determine in my head what I want to let you do. Because I fully expect that you're going to be back here again. Because you don't follow rules. And that's the most important thing you have to be able to do when you're on probation is follow the rules. Even if you don't like them or disagree with them. You need to be able to follow the rules, not do what you want to do.
I promise you will never see me.
I don't want to hear any more promises because you've been promising me from the beginning here.
I know.
Your actions speak a lot louder than words. But not following the rules is a complete recipe to go into prison, go into Mansfield, and that's what you're going to be doing. You can prove me wrong by your conduct, but your words, all due respect, don't mean anything to me at this point. Now, considering what to do, I certainly find at this point prison's consistent with the purpose and principles of sentencing. The nature of the offense here was worthy of a prison sentence. And you got a chance at that point to prove that you were sincere and genuine with your words that you were saying. And you couldn't even get out of jail. But I'll give you one last chance. I'll find your mental to available community control sanctions. But you're going to complete this program in JTP. You're not going to be just let out today and given credit because you served the extra 10 days with failing to comply with the condition of the court that you complete that program to begin with. I'm going to continue your community control sanctions. I'm going to order that you serve 75 days in jail. You have credit for 20 that you've served on the probation violation. The probation violation warrant was executed on April 16th. You have credit for 20 days in the PV. Now you get credit for the full amount of time that's been served, but again, 75 days in the PV, 20 days credit. You're going to enter and successfully complete the jail treatment program. You're also going to enter and complete the decision points program. If you don't complete that program before you're released, you'll finish it on the outside. You have to come back for a couple of class or two to finish it. All the other conditions are going to be the same. You're going to follow the aftercare recommendations of JTP and whatever they recommend, including any AA meetings if they recommend those. Not to use any drugs or alcohol. Submit random urine screens. Attend anger management. Obtain employment and education. Not to travel outside of the state of Ohio. You have no contact with the victim. You get a mental health evaluation and follow the recommendations. You make restitution in the amount of $2,406.16 and pay your costs and fees. Megan, anything else that we need to discuss? All right, I'm forgetting or should consider?
No, Your Honor, thank you.
So, Mr. Package, you understand the conditions of your probation?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
I need to advise if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another new offense while on probation, another motion to terminate will be filed. And if it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions like I did today, or I can and will terminate your community control sanction and send you to prison. It'll be 18 months in prison. That's what's hanging over your head. You understand that?
Yes, Your Honor.
So prove to me by your actions that you're sincere and that this isn't going to happen again. That's all. Nothing else is going to mean anything to me. You understand that?
Yes, Your Honor.
Mr. Wolf, anything else for the record?
No, Judge, thank you.
And that sentence of 18 months will be consecutive to any other term the defendant is serving at the time or gets sentenced to at that time.
Thank you, Judge.
present here in two cases, 22 CR 783 and 23 CR 369. Both of these cases are captioned State of Ohio versus Sebastian Shabazz. We're hearing a motion to terminate community control sanctions. Defendant was previously placed on community control sanctions to this court. The motion to terminate was filed. Defendant previously waived probable cause. No cognizance bond was set at that time. We're present at this time for the final hearing. Defendant is here in court, and he's with his attorney, Mr. Scott Ramsey. Mr. Ramsey, what is the defendant's intention at this time regarding the final hearing?
Your Honor, we would like to proceed with the final hearing. He admits the violation, Judge.
So we want to waive the hearing and admit to the violation?
Waive the hearing and admit to the violation.
Mr. Shabazz, you have been charged with violating the conditions of your community control sanctions. Specifically, it's alleged you violated two separate rules. Rule 1 requires you to obey all local, state, and federal laws. And it's alleged that on September 27th, you were arrested by the Cleveland Police Department and charged and ultimately indicted on multiple felony charges, which resulted, my understanding is, in you being convicted of 2 misdemeanor offenses that occurred and were committed while you were on community control sanctions to this court. Second violation is Rule 11, Conditional 3, which requires you to comply with all special conditions set forth by the court. And the condition that's alleged here is that you were to obtain a drug and alcohol evaluation and follow their recommendations, and you were unsuccessfully discharged from individual counseling at Signature Health due to being lost to follow-up and whereabouts unknown. Now, you have the right to have a final hearing regarding these allegations, which is a hearing where the state of Ohio will be required to prove the actual merits of what they're alleging. You could have either of these hearings. You can have this hearing, but you can also waive that hearing and plead guilty to the violation. Your attorney has indicated he believes that's what you want to do. Is that correct?
Yes.
Well, before I can accept your waiver and your admission, I need to make sure you understand the potential penalties you face if you're found to have violated your community control sanctions. If in fact that did occur, the court could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that in 22 CR 783, it could be anywhere between 6 to 18 months in prison. In 23 CR 369, it could be anywhere between 6 to 12 months in prison. I could run those two sentences concurrent or consecutive to each other. So if they're consecutive, you're facing a possible 30 months or 2.5 years in prison. I could also order that be served consecutive to the term you're currently serving out of Erie County. So do you understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes, sir.
Well, having been so advised, what do you want to do at this time? Do you want to have either of these hearings, or do you want to have the final hearing, or do you want to waive that hearing and plead guilty to the violations?
I'll waive the hearing and plead guilty.
Very well, then as to the allegation you violated Rule 1 by having been convicted of new criminal offenses while on community control of this court, what is your plea to that?
Guilty.
And as to the allegation that you were unsuccessfully discharged from your individual counseling at Signature Health, what is your plea to that?
Guilty as well.
All right, I'll accept your pleas of guilty. Mr. Ramsey, is there any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Your Honor, Sebastian is very sorry that he's here before you. He understands and we understand that you gave him an opportunity at community control sanctions, and for him to abide by those things, he could have avoided prison. He has had contact, as the court's been informed, and I was informed as well, with the victim in the Cuyahoga County case, but I want to let the court know he's had no contact whatsoever with the victim in the 2 cases before this honorable court. He is very sorry, Judge. He has a baby with this young lady, the Cuyahoga County victim. They have a baby together he's never met. The baby was born, after he was incarcerated after September of 2024. That case resulted in the conviction of, with 2 misdemeanors, as the honorable court knows. And really, to be honest, Judge, without getting into any details, he entered that plea because of communications that he had with the victim in that case. And so it was a situation, and I'm sure this court sees it a lot, where the victim in that case was not going to come forward for whatever reason. We don't have to get into the facts, but because he had that contact that he was not supposed to have with her in Cuyahoga County, it led to him pleading guilty to 2 misdemeanors. And then, of course, he went out to Erie County where he had a case, and he was given 1 year out there. While I was out there for that Erie County case, ironically, and I didn't say this in chambers, the probation officer in the Erie County court told me that, well, the judge in Lake County is going to sentence your client to prison as well. I said, how would you know that? I don't know how they would know what you were going to do over in Erie County. But we're asking this honorable court, Judge Maguski, I think is her name, out in Erie County, gave him 1 year for an F4 attempted violation of a protection order. We would ask this honorable court to consider allowing him to remain on community control sanctions, or if the court was inclined to give him prison, to sentence him to prison, Your Honor, to run that concurrent. He is sorry. I don't believe he has a malicious heart. He does not know how to handle his relationships with women, and there's been an issue there. He needs to be punished. He's being punished. We would ask the court not to give him a 30-month sentence and run a consecutive judge. We know it's in your power to do so. He's supported here by his mom. She's been to every court. He probably owes her gas money from going to Erie County and Sandusky, Cuyahoga County, and out here to Painesville. He's very sorry. He's violated. We know you gave him an opportunity you didn't have to give him, and you did. And we'd ask for one more opportunity for this court to be lenient. Thank you.
Thank you. Mr. Shabazz, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Once again, like he said, I want to apologize to the court because I know you did give me a chance and I messed up, and I apologize for that. It was never my intentions to, and I apologize, and it won't happen again.
Thank you.
Sorry I didn't stand, Judge, if you'd like us to stand.
This court reviewed the original pre-sentence report and investigation. Consider the facts and circumstances of the offenses involved in both of these cases, the nature of those offenses, our history on probation with the court and our probation department, and the nature of these violations. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-2911. For the factors in 29-2912, I'm going to incorporate all the findings I made at the time of the initial sentencing regarding the seriousness factors and the recidivism factors, with the additional finding today that the defendant has failed to comply with previously imposed sanctions ordered by the court, which is a factor indicating recidivism is more likely. In fact, the violation is that he committed a new crime, so if recidivism actually happened. At this point, the court notes the defendant is currently serving a prison sentence for an offense that was committed prior to the defendant being sentenced by this court. Though it was committed while he was on bond to this court in 22 CR 783. this time, the court finds that prison is consistent with the purposes and principles of sentencing. The defendant is not amenable to any available community control sanctions. Therefore, to be the sentence of this court, then 22 CR 783. Defendant served a term in prison of 12 months. Has credit for 130 days he's served. Case 23 CR 369. Defendant served a term in prison of 8 months. Has credit for 58 days he's already served. I'll run the prison terms in those two cases concurrent with each other, but they're going to be served consecutive to the prison sentence he's currently serving. Not going to give him, if I give him concurrent time, he's not getting punished at all for this case, and that makes no sense at all to the court. Plus, as I indicated, he committed the Erie County case while he was on bond to the court in 22 CR 783. And consecutive service is not disproportionate to the seriousness of his conduct and the danger he poses to the public. And I believe, as I indicated, it's necessary to punish the offender. So it's an additional 7 months, approximately. You need to advise you in both of these cases, upon your release, you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation, with a maximum of 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Defendant's ordered to pay all costs. Is there anything else for the record, Mr. Ramsey?
No, thank you, Judge.
Honor, here this morning a case captioned State of Ohio versus Jalen Spikes, case number 24 CR 000151. We were last here on April 3rd, at which time the defendant entered written and oral pleas of guilty to count 2 vehicular assaults as amended, that being a felony of the third degree in violation of 2903.0882. Count 3, failure to comply with the order or signal of a police officer, that being a felony of the third degree in violation of 2921.331B. Count 4, having weapons while under disability, felony of the third degree in violation of Revised Code Section 2923.13A2 with an accompanying forfeiture specification regarding contraband and instrumentalities pursuant to 2941.1417 and 2981.04. Count 6, improper handling firearms in a motor vehicle, felony of the fourth degree in violation of 2923.16B of the Revised Code with an accompanying forfeiture specification as well. And then count 7, as aggravated possession of drugs, a felony of the third degree in violation of 2925.11 of the Revised Code, and then a forfeiture specification regarding contraband or instrumentalities with that as well. The case was then referred for a pre-sentence report and investigation, victim impact statement. We are here today for purposes of sentencing, and the defendant is present with his counsel, Mr. Timothy Deeb.
Mr. Deeb, any reason not to go forward with sentencing?
No, Your Honor. We're prepared to proceed at this time.
Anything you want to say on behalf of your client?
Prior to myself addressing the court, we have 2 people that would like to address the court on Jalen's behalf, if we may.
Hey, sure. All right. Whoever wants to speak at this time may do so. Just state your name, spell your last name for our court reporter, and say whatever you'd like me to know.
Catherine?
Catherine Card, C-A-R-D. I just want to, before you take into consideration, he's a family man, spends time with his family, he's there for his kids, big help to his community. He'll give you the shirt off his back if he needs it. He's not here to hurt nobody. He just was having a rough day. We made mistakes. I feel like he's learned from him. His kids really need him out here. Family needs him. He's needed. He's not a troublemaker. He hasn't been in trouble in years. I think he's learned from this mistake. That's all.
Thank you.
Next we would have Paul Anderson. Paul?
Good afternoon, Judge.
Yep.
Like to extend my gratitude.
What's your name, sir?
My name is Paul Anderson.
Is it O-N or E-N at the end?
S-O-N.
That's O-N. Thank you.
I would like to extend my gratitude for allowing me to speak on Jalen's behalf. I just want to speak to his character. He's a great father. He's a hard-working man. He just made one bad decision, and I don't want to say I'm kind of glad it happened to him because that's a bad choice of words, but I just feel like things like this need to happen because I was explaining, we were talking about how you can do all these things over here that's good, 100 good things, one bad decision, one split second, that's who you will be judged as. We can come here and say he's a good guy all we want, but unfortunately the charges say what they say, and the state saying what they saying, and he pled guilty. So it'll be disrespectful to the courts to say he's an angel, but I just wanted to sit up and just, he's not a monster. He's not who the charges are indicative of him. I just wanted to express that on his behalf. Thank you.
Thank you, Mr. Anderson.
Your Honor, on Jalen's behalf, in this instance, he was concerned about losing his vehicle, which is extremely important in his lifestyle. It's a car that he borrows from his friend Caitlin, and he was looking to see if he could make that his own. He did have a suspended license that was problematic and something that would have been extremely difficult for him to get valid. On this occasion, Willoughby had originally stopped him, and the month prior to that, or shortly prior to that, in October, he had been stopped. They impounded his vehicle. It took him over 30 days to get that vehicle released. He did plead guilty to that DUS charge. And the problem that they had was the vehicle was not available for performing simple tasks like just getting to work, going to see his children, giving people rides, another way that he made money. And during this time, since then, when he got the car back, Jalen's been hustling to do whatever he can. He doesn't have his GED. He doesn't have any formal training in any computer-type aspects, but he has maintained employment, as you can see from the PSI through the years. He does work to maintain his employment. He was working, doing eviction notices, cleaning out properties, and maintaining them for a construction company. And on occasion, he had been threatened, he had been accosted, and was concerned about that. While he knows he should not have had a firearm in his possession at that time, and it ended up being stolen, being a convicted felon, he couldn't get the firearm through normal means. He got it from somebody on the street, and it was for his protection, which does not, it's not defense or anything, it just explains why he had it on his person this time. And as he expressed in his pre-sentence report, he does have drug issues, not alcohol issues. That's not something he uses on a regular basis, and told the court that, but he's had his opiate issues, and he was using street drugs at the time, which obviously he has no idea what was in them, and that's not appropriate to do, but it was what he was using to accommodate his needs at the time. On this date, Your Honor, he thought the vehicle was going to be impounded, he was going to be taken into custody, and that would have affected his family and his employment significantly, and he panicked and he took off from the city of Willoughby. He went for a short period of time to Euclid. He went and did some work, did some papers that he had to drop off, and then he went to the barber shop to get his hair done. At that time, there was a gentleman who needed a ride. He was going to be going to Painesville, so he told that guy for $10 I'd give him a ride. He didn't have anything to do with this. He just happened to be a passenger who said, okay, fine, I'll give you $10 for a ride. And as Jalen was pulling out, as the court has seen, when he's leaving that parking lot, that's when the officers stop him. And during that stop, he sees the officer to his right that is turning around and coming towards him with lights on. He sees the officer directly in front of him. He panics, puts his car in reverse after a few seconds, and as he's turning back, the officer Kenza, sorry, I'm pausing that, he's pulling up behind him to eliminate his ability to lead from the back or from behind. And in his recklessness and slamming his car, stepping on his gas and going back very, very quickly, that caused the accident and the injuries to the officer. He stated in his pre-sentence report he's been apologetic for that. He wasn't trying to hurt anybody. He just panicked and he was trying to get away so that he was thinking short term that I can get back to work, I won't use the vehicle, and I can make things better, but that's obviously not what happened. He made things much, much worse. And in that brief period of time, he's affected his life very significantly. To understand that the state is asking for significant time, he's understanding that prison is something that is in all likelihood going to happen, and mandatory in this case, based on what he's pled to. He would ask the court for leniency and in the interest of justice based on the conduct he's performed. We believe that a sentence in the range of 1 year, 9 months, which would be the minimum up to 4 years, would appropriately protect the public and punish the offender in this case, based on what the conduct was and based on the person that he is, as this pre-sentence report indicates. I know that he would like to address the court as well, Your Honor. Thank you.
Thank you. Mr. Spikes, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, I would like to say, first off, that I apologize to the officers and my family and friends.
Hang on, is that on the hallway?
Yeah, that's a phone.
Go ahead.
Yeah, I would like to say I apologize to the officers and my family and friends for putting them in a situation like this, and to my family for not being there for them over this time that I've been gone, because I'm a big help to everybody, and they lean on me for real. And I would just like to say that I take full accountability for everything I did. I did what I did. I accept the consequences. And I would like to say that I just want to say that at the time that I did everything, I wasn't even thinking right. I was just thinking I got 3 kids in 3 different cities, and I got to have a car to go from city to city to city. And the last time I didn't have a car, when it got taken, it took me about a month or 2 to get it back, and I was just hearing it nagging, and I did not want to go through that again. And basically, I needed it to go to work too, because if I don't work, I can't eat, I can't feed my kids, and none of the mothers of my kids have jobs. None of them, they don't even got a car. So I'm the one that they lean on.
Is there anything else you'd like to say?
Yeah, I would like to say that I just want to get another job somewhere else and live out of Cleveland, Ohio, for real. If I was to get out today, I would move somewhere in Lake County or Ashtabula or something where I ain't have to worry about and get a regular job, so I don't have to worry about nothing, carry another firearm or doing drugs again. Like, 'cause the drugs actually help me get through the day. It helped me get up, go to work, because it's dangerous. And what I do is dangerous, because I knock on doors and serve eviction notices to people who probably already mad at getting kicked out. And I heard stories and I watch stuff on YouTube where people get mad and do all kind of things to people who just doing their job, repo mans and everything.
That doesn't give you the right to carry a gun.
Yeah, it doesn't.
So you should probably find a different work then.
Yes, that's one thing I will do.
And the need that your family has doesn't give you a right to drive a car. I mean, you give all these explanations, and your attorney says they're not excuses, but I don't know what else they are. Explaining why you did what you did. Well, you broke the law. You're not allowed to do it, and you did it. It's not, just because you have these certain circumstances doesn't mean it's okay.
Yeah, and that's why I take full accountability for that. And I accept the consequences for anything, because I know it wasn't right.
All right, thank you, Mr. Spikes. Mr. Deeb, anything else on behalf of the defense?
Your Honor, we'll be preparing an affidavit of indigency shortly after this.
Ms. Linden from the state of Ohio.
Thank you, Your Honor. Your Honor, as I indicated in chambers, the state is recommend 10 years. I want to kind of go backwards a little bit with some of the things that, first of all, the defendant said, that he was just doing his job when he was serving the eviction notices. Well, Officer Continenza was just doing his job on this day as well. And not only that, he has a family, he has people that rely on him, and the defendant put him in a position where he couldn't do that because he was injured as a result of this. So I understand what they're saying in terms of that he's a family man, he's a good dad, he's a hardworking man, but so is Officer Continenza, and he didn't deserve that. He didn't deserve to have that happen. And when you look at the short distance that was in the video, you take into consideration the fact that there's $22,405.15 worth of damage to a cruiser. And that's just to the cruiser. That's not even the injury then that's caused as a result of him ramming into Officer Continenza, who then hits his head in there, ends up having to go in for medical treatment, has to go through physical therapy, is not able to work, is not able to do anything with his job. And we're talking about a person who's a police officer, so it's not a matter even of just sitting behind a desk. These types of injuries made it so that he was not able to work for a significant period of time. So we're looking at a victim here who's also a family man who also is big in helping the community and has a family who needs him. So although I can understand where they're saying that from the defendant's perspective, you have to look at the fact that the victim as well, Officer Continenza, had to go through that. Not to mention the fact that here's this poor guy that's given a ride for $10 in the car, and what happens to him? He's involved in this where he's going to be held at gunpoint as well to get out of the car. So that exacerbates this whole scenario. When you look at the fact that the claim is that he's just afraid of losing his car, it's not just that. I mean, he has a loaded firearm that's stolen in the car. He has 96 different types of pills in the car that have, and when you look at it, I mean, it's hard when you even go through the lab report on this to try and figure everything out. He has a plastic bag that has cocaine residue and THC residue. He has some scales with residue. He has a number of tablets. Some of those tablets have heroin, dispropanol, fentanyl, methamphetamine, and xylazine. Some of them just have methamphetamine and xylazine. Some of them have dispropanol, fentanyl, and then perfluorofentanyl. So we're talking about all these different types of drugs, and there's 96 of these. These are the drugs that on a routine basis are killing people daily, that people overdose on. And he has all these pills. So it's not just a matter of, oh, I was afraid I was going to get my car impounded. He knew damn well that he had that loaded firearm in his vehicle. He knew that he had these drugs with him as well and tried to get rid of those. So it's not just a matter of that. He's been using drugs and using these types of drugs since he was 23, so there's 7 years of that. And he says, he's threatened
10
before.
years of that. How old is he?
30.
Oh, I'm sorry, I said
30.
33 before, 30.
And so, he says he's been threatened before, and so he has a gun for protection. Well, he's not allowed to have a firearm regardless, and the court has already pointed that out. But the fact that he's saying that his vehicle is important to him, that's not more important than people's safety and not injuring individuals. And this whole thing started out originally in Willoughby, and even before, and I indicated this in chambers, but I want to place it on the record, even before he is chased in Willoughby, he's exiting the Cracker Barrel. He basically cuts across several lanes of traffic, makes illegal turns, and he gets onto I-90. Officer is behind him with lights, and he's going 85 miles an hour, accelerating, he passed a motorist on the ramp, crossed over 2 solid white lines and rumble strips. Then he gets into speeds up to 104 miles an hour in a 60-mile-per-hour zone, and
I want to make the record clear. He didn't plead to this at all.
Correct.
That's not the king.
this is just something to consider in terms of
He
what
didn't
he's
admit to it,
done
he
that
plead
day.
guilty to it. I mean, that hasn't been found. I know that's what the facts are, and he's not gonna, I want the record clear that he's not being sentenced on that conduct.
Understood, Your Honor, but in terms of what he's doing this day, it's not just a matter then of wanting to keep his vehicle. This is fleeing from the police. Then there's a flock hit, and that's why, because of the flock hit, that's why the officers get involved in this matter. So in terms of looking at that and looking what he's involved in that day, then looking at his history. He had, even before, when in his prison term, he had one case pending when another case was committed. And when you look at what they say in Cuyahoga County, and this is unusual for me to see, maybe not others, but they denied him participation in a program because of the negative institutional summary report that he had. They said that he should not be considered for transitional control or placement in an intensive program prison. I don't normally see that from Cuyahoga County. So again, there's serious damage to the cruiser. There's injury to Officer Continenza. And when you're looking at the fact that he's under suspension at the time of the offense and using someone else's car while he's doing this, then tries to conceal the drugs that he has. So I've gone over the types of drugs that he had and the fact that he had this loaded firearm. The firearm was stolen out of Cleveland as well. So again, this is not a situation where he's just like, well, I'm afraid of losing my car, or I'm afraid that I'm not going to be able to care for my kids. He's afraid of getting caught with a loaded firearm that's stolen and drugs in his car. So we are asking for a prison term of 10 years. We're asking on the vehicular assault for 5 years for the 60 months. For the failure to comply, consecutive time of 2 additional years, a year on the weapons under disability and improper handling, and then 2 years on the aggravated possession of drugs with the forfeiture of all the contraband and or instrumentalities that are involved here, restitution in the amount of $22,405.15, a lifetime driver's license suspension, and the mandatory fine as well. I'm not sure at this point in time if Officer Continenza wanted to speak at all. I know you submitted a victim impact statement, as has Willoughby Hills.
Did you want to speak, sir? You don't have to. I did read your statement.
I'll just say a few quick things here. Last name spelled Continenza. I just want to thank the courts for allowing me the opportunity to talk. I've listened to everybody. I've unfortunately witnessed this entire thing. I don't believe Mr. Spikes is a naturally bad person at heart. I think he did make a conscious decision that night to try and evade arrest, knowing that he did have a firearm, and as the attorney stated, 96 different fentanyl-related pills in his pocket. This isn't a personal use type of drug. This isn't a personal use amount. This is I'm trying to make some cash and sell some drugs. The situation is unfortunate, but at some point there needs to be consequences, and there needs to be some type of repercussion for people's actions. Like stated earlier, I do have a family. Today's actually my daughter's first birthday, and instead of spending time with my family, I'm here in court making a statement for something that, in my opinion, should never have happened. If things would have just went the way that they should have, when Willoughby attempted to stop him the first time, none of this would have happened. We wouldn't be here for this. He would have gotten probably a ticket for DUS and maybe a few years for the gun and drugs, but the aggravated vehicular assault and fleeing and everything else that accompanied with that, it just compounded to what it is today. And I just hope the courts can see that and hopefully make a correct decision on the sentencing. So I appreciate it.
Thank you, sir. Ms. Linden, anything else for the state?
No, Your Honor, thank you.
This court has reviewed the pre-sentence report and investigation. I received the victim impact statement, as I mentioned. I've read and considered that. I've considered the facts and circumstances of the offenses involved, for which the defendant pled guilty, the nature of those offenses. I've considered everything that's been said here in court today by the defendant himself, his lawyer, Mr. Deeb, the family members that spoke on his behalf. Also considered the prosecutor's comments and recommendation. And all of this was considered by the court in light of purposes and principles of felony sentencing set forth in 2911 of the revised code. As for the factors in 2912, factors indicating the conduct is more or less serious. Give me 1 second. As for the vehicular assault, the court will note that the defendant was high on fentanyl at the time he committed that offense by his own admission, which makes the offense more serious. I mean, you're lucky with the charge that you pled guilty to. It certainly could have been a much more serious charge, perhaps, with being under the influence at the time. For the failure to comply, the court notes again the defendant was high on fentanyl at the time. He was driving with a suspended license. Victim suffered serious physical harm as a result of that conduct. As for the weapons charges in counts 4 and 6, the court will note that the weapon was stolen. The gun was a stolen gun at the time. It makes that more serious. These weren't just also split-second decisions. This was criminal behavior that was going on all day long. No factors indicate any of the conduct is less serious than normal. As for recidivism factors, the court finds the defendant has a history of criminal convictions. He's previously served prison terms before. He's not responded favorably to previously imposed sanctions. Drug abuse problem that relates to the offense. He hasn't done anything to address it. He's been using heroin daily for the last 7 years. That's what you said. You told the probation officer since the age of 23. You've been using the pressed pills. Well, you've been using marijuana every day since you've been 13, so that's 17 years. And your record shows that too. I've never seen as many possession of marijuana charges. But then you've been using Percocet, pressed fentanyl at the age of 23. It started and you used it daily until your arrest in this case. You haven't done anything to address that. neocap in 2016 as a condition of probation, but that was 9 years ago. No factors indicate recidivism is less likely. Defendants has explanations for all this conduct. Well, he says he recognizes it's criminal. He justifies it and thinks apparently that I work in this bad field, so I need a gun. It doesn't matter if I'm not allowed to carry a gun. I need a gun, so I'm going to carry a gun. I need to drive, so I'm going to drive. It doesn't matter if I'm not allowed to drive, or if I don't have a license to drive, or if I don't even have license plates in my car. I'm going to drive. He doesn't follow the rules or the laws. He just does what he needs to do. And there's a history of this. Count 2, vehicular assault charge carries with it a mandatory prison sentence. One of the rest of these are felonies of the 3rd degree as well, and carry no presumptions. Prison's consistent with the purposes and principles of sentencing, and the defendant's not amenable to any available community control sanctions. Therefore, it will be the sentence of this court. Then on count 2, charge of vehicular assault, defendant serve a term in prison of 48 months. On count 3, failure to comply with the order or signal of a police officer, sentence of this court, defendant serve a term in prison of 12 months. On counts 4 and 6, the weapons under disability and improper handling of a firearm and motor vehicles, the sentence of the court, defendant serve a term in prison of 12 months. Those two counts will run concurrent with each other. Count 7, defendant serve a term in prison for the aggravated possession of 24 months. Sentence is imposed in counts 2, 3, and 7 are to be consecutive to each other and consecutive to 4 and 6. For an overall prison term of 8 years in prison, he has credit for 466 days he's already served. You need to advise you upon your release from prison, you could be placed on post-release control for up to 2 years. Oh wait, the failure to comply is offensive violence, right?
Yes, Your Honor.
Yeah.
It's a mandatory
Yeah.
1 to 3.
Because there's clearly cause serious physical harm. It's right that you can, upon your release from prison, you'll be placed on post-release control for at least 1 year, up to possibly 3 years. If you violate any terms of your community control, the parole authority may return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half the term imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. On count 2, the court will suspend the defendant's driver's license for 5 years. On count 3, it's suspended for 13 years. Those will be concurrent. There's a mandatory fine on count 7. I'm going to impose it at this point, but assuming an affidavit of indigency is filed, that'll be waived. Make sure it's filed prior to the sentencing entry.
Thank you, Your Honor.
An order the forfeiture of whatever contraband and instrumentalities are set forth in the forfeiture specifications. Defendant's order to pay all costs incurred in this action. And an order restitution to the Willoughby Police Department in the amount of $22,405.15, which is the damage to the vehicle cruiser that was not covered by insurance. As for consecutive sentences, the court notes that count 3 must be served consecutive to any other prison sentence. But regardless, the other counts being consecutive, court finds it's necessary consecutive service to protect the public from future crime and to punish the offender, that it's not disproportionate to the seriousness of his conduct and the danger he poses to the public, and that at least 2 or more of these offenses were committed as a part of 1 or more courses of conduct, and the harm caused by 2 or more of the offenses is so great or unusual that no single prison term for any of these offenses committed as any part of any of the courses of conduct adequately reflects the seriousness of his conduct, and that his history of criminal conduct demonstrates that consecutive services are necessary to protect the public from future crime by the offender. I think that covers everything. Ms. Linden, is there anything else the court needs to address or omitted?
Your Honor, is there an amount of the mandatory fine?
I thought I said
mean,
5,000. If I
okay.
didn't, then that's what I meant.
All right, thank you, Your Honor.
I may not. Thank you. Anything else?
No, Your Honor, thank you.
Mr. Deeb?
No, Your Honor.
We're here today in the state of Ohio versus Blake Grubb, case number 24-CR-1235. The defendant is present with counsel Nicolette Tomazik, and we're set today for a sentencing hearing. We were last before you on March 31st, 2025 for a change of plea hearing, and at that time the defendant pled guilty to count 2, receiving stolen property at felony of the 4th degree. During that hearing, a pre-sentence report and victim impact statement were ordered. That report has been completed and a victim impact statement has been returned. At this point, the state would ask that the balance of the indictment be dismissed, and then the defendant has 34 days of jail time credit. Thank you.
Ms. Thomas, any reason not to go forward with sentencing?
No, Your Honor, we're prepared to proceed with sentencing today.
Anything you want to say on behalf of your client?
Yes, thank you, Your Honor. We'd like to ask the court today to place Mr. Grubb on community control sanctions. In speaking with Mr. Grubb and reading his pre-sentence report, it's very clear that he is extremely remorseful for what he has done. He indicated to me in his pre-sentence report, he didn't realize how bad it got and how out of hand it got. He said there was some sort of believes there might be some sort of compulsive issue, and that's why he continued to take from his old employer's Ace Hardware. I know we didn't do a mental health evaluation for the pre-sentence report. However, Your Honor, if you would place him on community controls, I do believe a mental health evaluation, mental health treatment would greatly benefit Mr. Grubb. He also is working, he currently is working at Park Street. I did speak with his boss. His boss also did send a letter to you, Your Honor. So he does still have a job lined up. You know, his boss said he is a very valuable asset. They are a small company, and they do want Mr. Grubb to return to work as soon as possible. Mr. Grubb also does have he does have 2 children, but it's only his 13-year-old son that lives with him. The son is currently living with his grandma, who is much older, and she's having a very difficult time taking care of the son. His mom does stop over there, but I do think it'd be very beneficial to have Mr. Grubb back in his son's life. As I said, Mr. Grubb is very, very remorseful. In conversations I've had with him, he knows he made a huge, huge mistake. Thank you.
Thank you. Mr. Grubb, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor.
Good.
I'm a firm believer that good people can do bad things, and mistakes don't automatically categorize them as bad people. The difference lies in having remorse for those actions and taking accountability, and an honest intent to fix what wrongs they can. And what I've done is nothing short of terrible. I've betrayed trust given and destroyed relationships I valued deeply with people who genuinely cared about me. And while I still offer an apology, I know they're going to fall on deaf ears, as they probably should, as the time for that is long past. I can't change what I've done. I can only move forward and strive to do what I can to fix the things that I can and repay the debt that I owe. Overall, I try to be a decent man and try to do everything I can for those around me. My son's soon to be 13 and relies on me entirely. I have a 15-year-old daughter who I try to maintain a relationship with, and I take care of my 91-year-old grandmother who fell on Easter. And had fractured a couple of ribs in an event that I feel I'm entirely responsible for. I take care of my neighbor's yard because her husband is dead and she can't really take care of her yard on her own because she's disabled. In the winter, I take care of her driveway, clean it out, and make sure that her car's always accessible. And I show up to work on time every day, and I hardly ever miss a day unless there's some really great need. When I come home, I largely work around the house and garage until bedtime, and I don't drink really. I used to, and I got over it. I don't do any illegal drugs. The one thing I do essentially amounts to an over-the-counter anti-anxiety medication. I say all this not to make some claim to accolades or that I'm some wonderful human or anything like that. Just to point out that I'm not some sort of criminal risk, and I made a terrible mistake. And one that I've been beating myself up for, and continue to do so. As they say, nobody's harder on you than yourself. And even without the fear of losing my child, losing my dog, losing my truck, it's still, I beat myself up over it. And thank you for listening, for taking the time to listen to what I had to say. I appreciate it.
Thank you. Ms. Thomas, you got anything else?
Just one more thing, Your Honor, with regard to the restitution. I did discuss the restitution amount with Mr. Grubb, and after conversations in chambers, I just asked that we could keep it open for review down the road. Thank you.
Thank you. For the State of Ohio, Ms. Bell?
Thank you, Your Honor. Mr. Grubb was an employee of Ace Hardware for over 7 years, and over that time, he became close with the owners of the store. He worked his way up from sales associate to assistant manager, and he became very close with the owners. They considered him to be a family member. They really took him under their wing. And he violated their trust repeatedly and systematically, stole from them. And this happened over months. And while the defendant doesn't have a very long criminal history, I believe it's 2 misdemeanors, he really dipped his toe into the criminal world in a big way here. The state does not believe that prison is appropriate. The state would join the defense in a community control recommendation. However, the state would ask that it include some sort of treatment and then also some mental health component. Thank you.
So, Mr. Grubb, what did you do with all the stuff that you took?
Most of it I kept and just used.
Why did you need, I don't know, 10 leaf blowers or 10 of the same exact thing?
Honestly, I don't know.
You said most of it. What did you do with the other stuff?
Nothing I can think of. I used pretty much everything.
Nothing you can think of. You said
used-
you used most of it.
Most of it just sat on the shelf, honestly.
What was the point of it?
I don't know.
To steal the same exact thing over and over and over.
I don't know.
You weren't selling it.
No.
You being honest?
Yes.
That makes no sense. You had a little store in your garage.
I agree. It didn't make any sense. That's why I think there was some sort of compulsive act to it, just because I can't even give you a reason. It was stupid.
The only thing that makes sense is that you're selling it. Making money. Because it makes zero sense to... I saw the pictures of your garage and it was a little store. In the store. Probably more stuff in the store than they had in their store by the time it was over. It's not a mistake. Everyone's referring to this as a mistake. A mistake is not when you systematically and have a scheme and a plan and do something over and over and over. You know, most of the crimes we deal with here on a daily basis, the criminal intent is a split second. Someone loses their cool, you know, I don't know, takes a beer bottle, cracks it over someone's head. It's bad and the person gets seriously hurt. But the criminal intent, which is involved in a case like that, is nothing. The person did it intentionally, but it was formed and created in a split second and over with. That's most of the cases that we deal with. But a case like this, where it goes on and on and on over a period of time, and it's just not a split-second act to commit the offense, but you got to plan it, you got to cover it up, you got to scheme. And that's not a mistake. Well, this court has reviewed the pre-sentence report investigation. Consider the facts and circumstances of the offense involved, the nature of the offense. Consider what's been said here in court by the defendant, his lawyer, the prosecutor. I received victim impact statements. I've read and considered those. All of this is considered by this court in light of the purposes and principles of felony sentencing set forth in 292911. For the factors in 292912, the court finds that the defendant's relationship with the victim facilitated this offense, that the defendant's occupation was used to facilitate this offense. The victim suffered serious, not just economic harm, but psychological harm as a result of the conduct involved. You alluded to it, but they considered you a family member who they put their full trust in, and you just violated that over and over and over. That makes this theft much more serious than the normal theft we deal with. There's no factors indicating the offense is less serious. As for recidivism factors, the court notes the defendant has a couple of prior misdemeanor convictions. No, one prior disorderly conduct, intoxication. The court also finds the defendant violated the conditions of his bond in using marijuana while on bond. There's also a drug issue with marijuana. Doesn't necessarily think that's the case. He said he's never committed crime. He's been smoking marijuana for I don't know how many years. Let me see. Marijuana may be legal at this point, but that just happened a year ago. She's been using it pretty much for 17 years. Apparently it is a problem. You say it's not a problem. But you're on bond. One of the conditions of your bond is that you don't use drugs, and you couldn't stop yourself from using it. So you either have a problem, or you just don't care what I say, or you don't care what the orders were, and you're going to go ahead and do whatever you wanted to do. He believes pot fixes your issues, I think is what you said. Anxiety and stress. But my point again is that if you didn't have a problem with it, you would have been able to not use it when you were out on bond like you weren't supposed to. But yet knowing that your liberty was at stake and that if you used, you were going to go to jail, you used anyway. That's either a problem or, again, you don't care what the court says. But violating your bond is a condition that indicates recidivism is more likely. For factors indicating it's less likely, the court finds the defendant has led a law-abiding life for a significant number of years. Again, he's got the one conviction as a, disorderly conduct conviction. No delinquency adjudications. There appears to be genuine remorse. Under 29-29-13b1, again, the court notes the defendant violated his bond, which is a factor that overrides presumption for probation, permits the court to impose a prison sentence without having to make any specific findings for that. I will find at this time, however, that prison is not consistent with the purposes and principles of sentencing, and the defendant is amenable to an available community control sanction. So I'm going to put the defendant on community control sanctions for a period of 2 years. But there are going to be consequences. In these 34 days that you've served so far, 34 days are on you. You were out on bond. You were given a bond, and the reason you're in jail is because you violated your bond. Well, I'm not going to alter and change what I think the appropriate sentence is because you already have credit for 34 days, and you'd have to do more time in order for me to accomplish what I want to accomplish, but I'm not going to, I'm going to do that still. 34 days, again, they're serving around you. On an order the defendant served 94 days in jail, he has credit for 34 he's already served, so there's 60 more days. I want you to, last 30 days, enter and successfully complete the jail treatment program, follow all their aftercare recommendations. I also want you to participate and complete successfully the decision points program. Upon your release from jail, you are not to use, upon your release from jail, you shall follow the aftercare recommendations from jail treatment. You're not to use any drugs or alcohol. That includes no marijuana use. Doesn't matter whether you have a prescription for it or not. You're not to use marijuana. You submit random urine screens. They must be negative. A positive screen is a violation. As far as AA meetings, whatever, if any, is recommended by aftercare will be the amount you need to do. Maybe they won't recommend any. I don't know. But whatever aftercare recommendations from jail treatment are made, including AA meetings, need to be followed. You're to obtain and maintain full-time employment. You're to obtain a mental health evaluation immediately after you get out and follow whatever recommendations are made in regards to any type of counseling or treatment. As far as restitution, the period of the indictment in this case was charging receiving stolen property for the property that you had that was seized, and that's what the charge was for. And the restitution, that amount is $27,856.55. That will be ordered. At some point, if we need to have a review hearing to address any credit that maybe you would receive, if the property gets returned to the victims that was seized, we'll have that hearing. We can do that multiple times if necessary. But at this point, that's the amount that's being ordered, because that's the amount that was seized and the subject of the charge that you pled guilty to. You pay court costs and supervision fees. Count one. Oh, wait a second. Let me see something. Count one will be dismissed pursuant to the agreement. I will release bond. There was, no, that doesn't look like a bond was posted, but bond's released. You only have one doctor and one dentist that can prescribe you medication, one pharmacy where you get them filled. Make sure probation knows who those doctors are, where the pharmacy is, sign whatever releases they need. And you're to take any and all medications as prescribed. Ms. Randazzo, anything else I should be thinking of?
Should there be a no contact with victim?
Yes, no contact with victims or their store. Restitution will be made through the probation department, so you don't do that directly to them. Mr. Grubb, you understand all the conditions of your community control sanctions?
Yes, Your Honor.
Any questions for me?
No.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit a new crime while you are on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years, I can impose more restrictive sanctions against you, or I could terminate your community control and send you to prison. If I did that, it would be 18 months in prison, which would be consecutive to any other sentence you're serving at that time for some other case, or that you're being sentenced to for some other case. I also, in regards to that restitution order, want you to get a payment plan with the probation department and make your payments pursuant to that payment plan instead of just waiting to the very end to address that. All right, Ms. Bell, is there anything else for the record?
Did you advise a PRC judge?
No, and don't do
You
that.
don't intend to?
No, I want to put someone on community control. It's not necessary.
Thank you.
Ms. Tomasic?
Nothing further, Your Honor.
Thank you.
you.
Thank you, Your Honor. We're here on the matter of the State of Ohio versus Matthew Barrett, case number 25 CR 000273. The defendant is present in open court with their attorney, John Fatika. We are set today for a hearing on the defendant's motion for treatment in lieu of conviction. The case was indicted on March 31st with 3 counts of drug possession, 1 count of possession of cocaine, and 2 counts of aggravated possession of drugs. A motion for treatment in lieu has since been filed on April 11th. Pre-sentence report has since been completed, and the defendant has 69 days of jail time credit.
Thank you. Mr. Fatika, would you care to be heard on your motion?
I would, Your Honor. As you can see from the PSR, Mr. Beard has no prior felony convictions. We acknowledge that he does have a misdemeanor record. I submitted some documentation regarding his time in the armed services. He has a persistent history of employment. He's a mechanic. That has added to his drug problem. He's a traveling mechanic, and I think he reached a point where he was living out of his car, fixing cars for drugs. But he's had an opportunity to spend time at the Lake County Jail. He's detoxed. There's a bed available for him at Stella Maris in a unit that's reserved for.
Did you take that letter back, or do I have it still?
If I took it back, I have another one. Can I approach?
Yeah, please. Thank you. Sorry to interrupt you. Yeah. Go ahead. I'm sorry.
But we would ask the court to consider intervention in lieu of conviction in this matter for the reasons stated in the motion and contained in the report.
Does the state have a position on the defendant's motion?
Your Honor, the state believes that he would be a good candidate. There are a couple of things that are of concern, and that's where he would be living. At the time of the offense, he was living out of his car. And also in the PSR did mention that he'd be living with his mother after previously being removed from that home. So that is a concern, but other than that, the state does believe he'd be a good candidate.
Well, Mr. Barrett, your attorney has filed a motion for intervention in lieu of conviction. I'm sure he's talked about this with you and explained what that involves, but I'm going to do that as well. But a motion for intervention in lieu of conviction is a motion that's filed when someone's committed an offense and they're claiming that they committed it because they were drug dependent at the time or had a drug issue at the time. And they're requesting the court to place them in a period of supervision with the probation department, but if they successfully complete the program, the supervision, case gets dismissed and you won't have it on your record, which is a big deal this day and age with not having felony on your record, especially since you don't have any prior felony convictions. So we don't grant these lightly. My concern in this case, quite frankly, is just what's been going on recently here. You committed this offense while you were on bond to Menor for their case, right?
Yes, Your Honor.
And then while you were waiting sentencing, and then you got arrested on this case, and then you committed another offense. Well, it was obstructing justice. I can't remember if it was Willoughby. I think it was Willoughby. No, it was Menor. I can't remember. Willoughby or Menor. An obstructing justice or obstructing official business, I think is what it was, while you were on bond in this case. So you're committing criminal acts while you're actually on bond to court and super being out on bond. What's going on?
My drug addiction took a hold of me, Your Honor, and being in the Lake County Jail, I realized what I've been doing, and I desperately need help.
When did you get out of service?
It was.
I have that information. It's not a quiz, but I don't have it right in front of me. It's been a while, or
it has been.
How old are you now?
I'm 34, Your Honor.
Okay. Well, I mean, you're eligible for intervention in lieu of conviction. The only factor that really comes to mind here is whether you're willing and able to comply with the terms of the intervention plan. It means you're going to have to follow the rules. You're going to have to follow the conditions that I have put in, the rules of probation. Are you going to be able to do that?
Yes, Your Honor.
I mean, there's no second chances with treatment in lieu of conviction. If you mess up, that goes away, you're going to be convicted and have the felony conviction. Now, doesn't mean you automatically go to prison. That's a possibility at that point. But in terms of losing the benefit of intervention in lieu of conviction, you don't get second chances on that. You understand that?
I understand, Your Honor.
It's something you want to do and try to do?
Yes, Your Honor.
I mean, if you, by doing intervention in lieu of conviction, you have to plead all 3 counts. If you don't do intervention in lieu of conviction, I think the offer was 1 count, correct?
It was 2 counts, Your Honor.
2 counts? So you're obviously pleading an extra count here, but that's something you want to do?
Yes, Your Honor.
All right. Well, I will find that you are eligible under 2951.041B, that you satisfy all the eligibility conditions. My intention is to grant your motion, but before I can do that, you need to plead guilty to the charge. And before I can accept your plea of guilty, I need to make sure you understand all the rights you're giving up by pleading guilty. I need to make sure you understand what you're pleading guilty to. And I also need to make sure you understand the potential penalties you could face if we ever had to go to sentencing. By granting intervention in lieu of conviction, I'm going to stay out further criminal proceedings instead of sentencing and put you in a period of supervision with the probation department. But if you should ever violate those conditions, as I was talking about, the stay of sentencing would be vacated. I'd find you guilty and we proceed to sentencing. So while we certainly don't want that to happen, it could happen. So I need to make sure you understand those potential penalties before I can accept your plea, to make sure you're entering this plea knowing, voluntary and intelligently, knowing everything that's going on. You understand that?
Yes, Your Honor.
All right. So I'm going to ask you a series of questions at this point. If at any time you have any questions for me, make sure you ask. If you need anything clarified, make sure you ask. If you want a moment to talk with Mr. Fatika, let me know that. All right?
Yes, Your
All
Honor.
right. Well, let's get started then. How old are you, sir? I know I just asked you that, but you're 34?
34 years old, Your Honor.
Are you able to read and write the English language?
Yes, Your Honor.
Any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court here this afternoon, have you any drugs or alcohol of any kind?
They put me on a cold medication for the last 5 days of my stay in the Lake County Jail, and that ended yesterday, Your Honor.
Okay. You under the influence of that in any way which negatively impacts you at all?
No, Your Honor.
Anything else? Medication-wise or drug-wise?
No, Your Honor, that was all.
Now, did you receive a copy of the indictment that was filed in this case? You should have probably got it about last month, beginning of last month sometime. You remember getting that?
Yes, Your Honor.
Did you have a chance to look that over at some point?
Yes, Your Honor.
Now, in that indictment, you're charged with 3 counts. Count 1 alleges on or about January 28th, 2025 in Wickliffe Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount was less than 5 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in that count?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, the charge also carries with it what we call a forfeiture specification, which alleges that during the offense you possessed or had some interest in property that was considered to be contraband or an instrumentality. Contraband is property that's illegal just by the nature of the property itself, whereas an instrumentality is some type of property that there may not be anything illegal about it, but it's being used in an illegal manner to facilitate a crime. You can't possess it for that purpose. Here, the contraband involved is alleged to be the drugs, cocaine, psilocybin, the mushrooms, and hydrocodone and acetaminophen. The whole point of this is that you forfeit any ownership interest you have in that property. Do you understand that?
Yes, Your Honor.
Now, counts 2 and 3 allege the same charge, aggravated possession of drugs. And what's alleged in these 2 counts is on or about January 28, 2025 in Wickliffe Lake County, Ohio, that you did knowingly obtain, possess, or use as the count 2, the psilocybin, the mushrooms, or in count 3 it would be hydrocodone acetaminophen. The psilocybin is a Schedule 1 controlled substance. The hydrocodone and acetaminophen is a Schedule 2 controlled substance. Both of those were less than the bulk amount, which makes each of these offenses aggravated possession of drugs, each felonies of the 5th degree. Do you understand what you're charged with in pleading guilty to in each of those 2 counts?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have a right to a trial. Now, a trial could be to me as a judge, where I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would get together. We meet here and they listen to all the evidence and then they make the ultimate decision whether you're guilty or not guilty. And that decision they reach and as each count would have to be unanimous, which means all 12 jurors would have to agree together, one way or the other, as each separate count, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty, you're giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. With him having the burden of proof, what that actually means is that it is his job, or he bears the responsibility or the obligation to prove you guilty before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when we speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt, which is the highest burden of proof we have in our justice system. And what it actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you could ever be found guilty of the charge. You understand that?
Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
Now, in order to try to do that, if we're going to have a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and that's called cross-examination. So he could ask them anything he wanted to, well, within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial, you can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not obligated to do that, but you have a right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further can request this court issue an order, and we call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
You realize you're giving up that right?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision. That is a choice that you and you alone would have to make. Do you understand that?
Yes, Your Honor.
And since that's solely your choice, what that really means then is that nobody else can force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness and force you to get up on the stand and testify. Your own attorney can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Also, if we were to go to trial and you were found guilty of any of these charges, you'd have the right to appeal or challenge that guilty finding to a higher court. By pleading guilty here today, you are giving up any right you have to appeal a guilty finding that could be made later on. As I initially said, with treatment in lieu of conviction, you're not going to be found guilty. But should you violate at some point and they ultimately find you guilty, you're giving up your right to challenge that guilty finding at that point. You could appeal the grounds for the violation, but in regards to being found guilty and any issues you could have raised up to this point, you're waiving that at this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all then regarding these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Now, do you understand a guilty plea is a complete admission of guilt? So it means you're admitting to the facts being alleged by the prosecutor, and we're not going to argue later that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
All right, as far as, well, also another effect is that normally when you plead guilty, you're found guilty and you're going to be sentenced. Again, I've explained that's not going to happen in this case. I'm going to stay any further criminal proceedings. I'll place you under the direction of the probation department with certain conditions. We'll create a intervention plan, and that will be what you have to do. Should you violate any of those conditions, as I also alluded to earlier, a motion to terminate your intervention in lieu of conviction will be filed. And if it's found that you violated, at that point, I would vacate the stay of criminal proceedings. I'd find you guilty of these 3 counts, and then we would proceed to sentencing. Now again, we're hoping that doesn't happen. We're not planning on that happening, but I need to make sure you understand what those potential penalties could be should it happen. So I'm going to review those with you at this time, all right? If you have any questions, make sure you ask. But you're pleading guilty to 3 felonies with a 5th degree, and each of these are punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes, Your Honor.
And since there's 3 separate charges here, if I impose a prison sentence, I would do it on each count, and as the judge, I have the discretion to run those terms either concurrent or consecutive. Concurrent means you serve them together at the same time, whereas consecutive means one after the other. Do you understand that?
Yes, Your Honor.
So in this case, there's a maximum possible prison sentence of 3 years if I were to impose 12 months on each count and run them all consecutive. Do you understand that?
Yes, Your Honor.
Now, you currently on probation or parole to any other courts or agencies?
Not that I'm aware of, Your Honor.
You know, you have that sentencing pending in what, I can't remember if it's Willoughby or Menor.
Menor, Your Honor.
That's a misdemeanor though, right?
Yes.
Okay. Were you on probation anywhere at the time? You said no?
No, Your Honor.
If a prison sentence were imposed upon your release from prison, you could be placed on what's called post-release control, sometimes referred to as parole. That's a period of supervision you would be on after you serve the prison sentence, and it could be up to 2 years in this case. Do you understand that?
Yes, Your Honor.
Further, if you were put on and sent to prison, you ever violated any conditions, well, strike that. If you were put on post-release control and you ever violated any of the conditions, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50%, or half, or whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Also, in regards to if you ever violated, if you had new charges pending against you, felony charges, or if you were currently serving a prison term, if I imposed a prison sentence, it could be consecutive to those new cases. Do you understand that?
Yes, Your Honor.
Okay. Now, there are other sanctions that could be ordered if we proceed to sentencing, and some of them will actually. You will be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment, if any that's applicable here. Do you understand that?
Yes, Your Honor.
If we ever proceed to sentencing, you could be fined up to $2,500 on each of those counts, so that's a max of $7,500. Do you understand that?
Yes, Your Honor.
If we ever proceed to sentencing, I would also have the discretion to suspend your driver's license for up to 5 years. Do you understand that?
Yes, Your Honor.
And also, I will forfeit, as I mentioned, any interest you have in any of the contraband that was seized at the time. You understand that?
Yes, Your Honor.
Now, if we did have to proceed to sentencing, you would be eligible at that point for probation, or what's called community control sanctions. Obviously, I would look at the nature of the violation that brought us back to begin with, and all the other factors, and then make the decision whether that was appropriate or not. Just because you're eligible doesn't mean it's automatic. You understand that?
Yes, Your Honor.
Now, if you were put on probation at any point, I would have the discretion to order a wide variety of conditions for you to follow, which could include an order that you serve local jail time up to 6 months. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all regarding the potential penalties you face by pleading guilty to these charges? Those are only penalties you face should you violate the intervention of conviction. But ultimately, the penalties you could face if that happened. Do you have any questions about that?
No, Your Honor.
Do you understand them?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to talk about this case with Mr. Fatika and have him go over everything with you and answer your questions?
Yes, Your Honor.
Are you satisfied with his advice and counsel?
Yes, Your Honor.
Has he or anyone else made any promises to you about what's going to happen if we should proceed to sentencing? Obviously, I've told you I'm going to grant your intervention, but if for whatever reason we have to go to sentencing at some point, has anyone promised you, made you any promises?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering this plea freely and voluntarily?
Yes, Your Honor.
All right, then, any questions for me at this point regarding anything we've talked about? The rights you're giving up, penalties you face, what you're pleading guilty to, how intervention in lieu of conviction works, anything like that?
No questions, Your Honor.
Do you need any more time to talk to your lawyer before we go forward with your plea?
No, Your Honor.
All right. Now what's going to happen at this point, the prosecutor is going to explain for me what he believes the evidence would show if we had a trial. I want you to listen to him and what he says, because I'm going to have some questions for you about that, all right?
Yes, Your Honor.
All right, Mr. Culotta.
Your Honor, had the case proceeded, the trial, the state would have shown that on January 28th, 2025, in Lake County, state of Ohio, the defendant was in possession of cocaine, psilocybin, and hydrocodone. Specifically, the defendant was operating a motor vehicle that was registered to a Chevy truck, but he was actually driving a Toyota Camry. The vehicle was stopped for that reason. A subsequent search of that vehicle revealed, again, cocaine, psilocybin, and hydrocodone confirmed by the Lake County Crime Lab.
So, Mr. Barrett, were you able to hear what the prosecutor had to say regarding what he believes the evidence would show if we had a trial?
Yes, Your Honor.
And what, if anything, did he say about those facts as he presented them? Are they true? Did you do what he said?
Yes, Your Honor.
Very well. That adds to count 1, charging with possession of cocaine, a felony of the 5th degree with the forfeiture specification. What is your plea to that count?
Guilty, Your Honor.
As to counts 2 and 3, each charging with aggravated possession of drugs, each felonies of the 5th degree. What is your plea to each of those 2 counts?
Guilty, Your Honor.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything we've just talked about. Before I can accept your plea, I need to make sure you understand this document, what it says, and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go through that document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Fatika, is that accurate? Did you review this with Mr. Barrett to answer all his questions?
Yes, Your Honor.
And did he indicate an understanding of the document to you?
He did.
Is that correct, Mr. Barrett?
Yes, Your Honor.
Do you understand what it says?
Yes, Your Honor.
Do you have any questions for me about what it says?
No, Your Honor.
It also appears you signed the document. Did you in fact sign it?
Yes, Your Honor.
Mr. Fatika, you witnessed that?
I did, Your Honor.
Mr. Knopf, you too?
Yes, Your Honor.
All right, thank you. Be seated. Very well, at this time, the court will accept the defendant's plea of guilty to count 1, possession of cocaine. Well, straight to, at this time, I'll accept the defendant's plea. Find the defendant knowing, intelligently, and voluntarily waived his rights. He understands the maximum sentence that could be imposed should we ever get to sentencing. And I'll accept the plea to count 1, possession of cocaine, a felony of the 5th degree, violation of 292511 of the revised code with the forfeiture specification, as well as counts 2 and 3. Aggravated possession of drugs, each felony is the 5th degree in violation of 292511. I am accept the plea, but I'm going to, at this point, grant the defendant's motion for intervention in lieu of conviction. I'm going to order a stay of all further criminal proceedings. I'm going to place the defendant under the supervision and direction of Lake County Adult Probation Department for a period of 2 years. And I'm going to order the implementation of the following intervention plan. So tomorrow he's going to Menor Court.
Correct, Your Honor.
I honestly don't know what they're going to do, but I know you said there's a bed available immediately, Mr. Fatika, but I'm assuming that means that it'll still be available in 2 or 3 or 4 days.
Yes, Your Honor. That was the impression I got from speaking with Ms. Rubka.
I'm going to order the defendant to serve 71 days in jail. He has credit for 69 days. Hopefully the next couple of days, at least Menor will take care of what they have to do. If you get sentenced by Menor to more jail time, then you have to do that before you can go anywhere. I don't control Menor. But I'm going to order 71 days jail, 69 days of credit. I'm going to order that you, upon release from jail, enter and complete the treatment program at Stella Maris, which is through the Department of Veterans Affairs. So I want to make sure you're in that program, the VA program, at Stella Maris. That's what I'll call it then, the VA program. Successfully complete the VA treatment program at Stella Maris. Follow all their aftercare recommendations. Upon your release from Stella Maris, following conditions. You have to use any drugs or alcohol. That includes even marijuana. You're to attend AA meetings pursuant to whatever recommendations Stella Maris makes, aftercare recommendations. So if they say you need to do 5 meetings a week, you do 5. If they say you need to do 3, do 3. If they say you don't need any, then you don't have to do any. But whatever their recommendations are for AA meetings will be a condition of your intervention plan. You understand that?
Yes, Your Honor.
Okay. And submit random urine screens. Again, they have to be negative. I want you to obtain and maintain full-time employment. You have 1 doctor, 1 dentist that could prescribe you medication, specialists, all right as well. Make sure probation knows who the doctors are that you get your prescriptions from. You can only get them from those doctors. You can only get your prescriptions filled at 1 pharmacy as well, and they need to know where that is. Sign whatever releases they may need in order to contact these folks, including the folks at Stella Maris. So you need to sign a release for that as well. So if they need to talk to anybody, they can. Pay court costs and supervision fees. I'm going to order the forfeiture of the contraband in count 1. Now, I have a concern about your housing, Mr. Barrett. You said you lived with your mother until they found out that you were living there and you weren't allowed to live there. And then you said when you get done, you're going back to live with your mother. So how can that happen?
At the time that I was not living with my mother, prior to the arrests, I wasn't paying rent, so I was kicked out. My rent can be paid with my veteran benefits after.
But your mother pays rent, right?
She was not. It was a strange happenstance where she told our landlord that I moved out.
Okay.
And then the landlord found out that I had been.
Yeah, but your mother, she lives rent-free?
No, she pays about $850 a month for rent, Your Honor. And before that period, I was paying $600 a month for rent.
Where?
At her house.
To who?
Robert Leach was the owner of the property.
In addition to your mother paying $850?
At that time, she was paying $650 or $600, Your Honor.
And so she's paying $600, and you were paying $650, whatever.
And then.
And then you told him that you moved out, so she just continued paying her rent,
Yes, Your Honor.
but
And
you
I-
never really moved out.
Correct, Your Honor.
Okay, you're not getting in trouble for this. I'm just trying to understand it all. Because it said that you used to live with your mother, but then you had to leave because you weren't allowed to live there. And then you say you're going back there, and I couldn't. If you weren't allowed to live there, now you're saying you weren't. They made you leave because you weren't paying rent. You're allowed to live there if you pay rent.
Yes, Your Honor.
I didn't get that from there. And they'll accept you back there if you're paying rent?
Yes, Your Honor.
They'll allow you to go back there?
Absolutely.
I know VA will help you with housing as well, but I just couldn't figure that out. All right, Nicole, have I forgotten anything here?
I apologize, Ritter. Did I miss the mental health eval?
No, you didn't. Let's do that for sure.
And
Yeah.
then, not to be difficult, but just based on we don't know what's gonna go on with mentor and transportation, Mr. Fatiga stated that the public defender's office would most likely be doing that transport. Would it be possible to do till next Wednesday, but release earlier if available, just to allow for time for scheduling with them if they already have something booked in the next couple of days for transport? Erin, who transports for them.
Is she not going to be able to do it in the next couple of days?
Yeah, I believe she will, Your Honor. If you could put a representative of the Lake County Public Defender's Office. If it's not Aaron, it'll be, we have an investigator, another gentleman that could take it.
Maya, what's the concern?
I just get nervous, what if mentor puts on days and then he's out, then how are we going to transport him?
Then what?
What if we lose that date and they don't have enough people to transport on that day, just giving a couple days buffer to allow to regroup.
You can leave it as it is right now.
Okay.
I understand what you're saying. So I will allow him to put in there that he's to be, when he's being released, be released to a representative from the public defender's office for it to be transported to Stella Maris. I mean, if something should happen with Menor, then we'll have to discuss it, because obviously when he's done with Menor, he'll have to be able to leave immediately. But we'll discuss that. That should happen. My guess is Menor's gonna let him do whatever you're gonna.
That's the impression I got, Your Honor. Whatever happens tomorrow, I'll let you know.
Okay. But I do want to order mental health evaluation, follow whatever recommendations that are made for any type of mental health treatment or counseling as well. All right, I think that covers it. So, Mr. Barrett, do you understand all the conditions of the intervention plan? Basically, ordering to get some treatment here and then not use drugs, work.
Yes, Your
Try to
Honor.
get back on track. You have to report to probation when they want you to, and initially it'll start off more frequent. If you're doing well, it'll be longer in between, but you have to earn that. But do you have any questions?
No, Your Honor.
I do need to advise you that if you fail to comply with the terms of this intervention plan, a motion to terminate your intervention in lieu of conviction will be filed. If it's found that you violated, at that point, I would vacate the stay of criminal proceedings that I just ordered. I'll find you guilty of the 3 counts, and then we'll proceed to sentencing, where any of the potential penalties that I just explained to you a few moments ago, including up to 3 years in prison, could be imposed. You understand that?
Yes, Your Honor.
All right. Mr. Knopf, anything else for the record at this point?
No, Your Honor.
Mr. Fatika?
No, thank you very much, Your Honor.
All right. Thank you all.
Your Honor, we're here for two cases, each involving the same defendant, each therefore styled State of Ohio versus Mr. Adante M. Simmons. Mr. Simmons is present today with his attorney, Ms. Nicole Novotny. On case number 25 CR 77, on that one we've been scheduled for a sentencing on that case as on April 1st of this year, defendant withdrew his prior plea of not guilty and entered a plea of guilty to one count, that being possession of fentanyl, a felony 4 under 2925.11a, and carrying a forfeiture specification. Your Honor accepted the plea and ordered PSR and drug and alcohol evaluations. We understand that that has not been completed. We have, however, read what is available from probation, and we are ready for sentencing on that case, Your Honor. There's no prior agreement as to sentencing. It should be noted that on that one, the defendant has 22 days of jail time served.
That's on the first case?
That is on the, yes, 25 CR 77, Your Honor.
That counts any time before plus since he's been arrested?
Yes, Your Honor, that's mine.
That's
22 days altogether.
22. Okay.
Yes. On the second case, Your Honor,
Okay. What about the second case?
25 CR 524. That's the new case. The state is proceeding by information on that one. One count possession of cocaine, a felony 5 under 2925.11a, and carrying a forfeiture spec. The info was filed on May 2nd of this year. Discovery has been sent. We do expect that the defendant will waive the indictment and withdraw his previously entered plea of not guilty and instead enter a plea of guilty to the information as stated. We also understand the defendant has agreed to be sentenced today. There are no prior agreements as to this one either, Your Honor. I think that is all. Thank you.
Ms. Novotny, any reason not to go forward with sentencing in the first case? Let's make sure we're on the same page here. That'd be 25 CR 77.
Your Honor, we would ask the court to reconsider the motion for continuance with regard to that sentencing. I know counsel previously filed two continuances last week. One was for global resolution, which we've already come here and it was delivered with regard to an information offer. With regard to the reasoning, from my understanding, and counsel found out last week when the one motion was filed that a pre-sentence report was not completed. From my understanding, there was 2 missed appointments. Ultimately, those appointments were missed according to my client, his fiance, that his fiance's car broke down and he had no way of getting to such appointments.
Did his phone break down?
Your Honor, with that respect, I cannot go into any more details besides that fact, but Your Honor, we're just asking for a pre-sentence report to be completed. Ultimately, my client does know and understands that if no pre-sentence report is completed, that ultimately the court can only consider prison with that respect and not a probation recommendation. We're just asking the court to reconsider that motion to continue at this time.
Well, that request is denied. This court advised Mr. Simmons when he was here at the time of his plea that a pre-sentence report was necessary in order for the court to consider probation as an option. Without a report, then the court could not consider probation, and he was specifically advised that if the court's not going to continue the sentencing hearing to a later day to get a report completed because the defendant didn't show up when he was supposed to. He was told all that. He knew the consequences of his failure to show up, and he just didn't show up. He never contacted anybody. He called the first time he was called. They rescheduled it, and then well, he did call. He just said he couldn't make it. He'd have to catch the bus. He didn't catch the bus. It's his responsibility to be here, and he didn't show up. And he was told what would happen if he didn't. And I'm not going to continue it. When I told him that I'm not going to continue it. So we're going to go forward on sentencing in this particular case. In the new case, if he wants to request a pre-sentence report, he can, but he's going to get sentenced on the first case.
Your Honor, with the second case, with the continuance being denied, we'd like to continue on with sentencing today as well.
Very well. Then we'll do the information first and then proceed to sentencing on both cases. Mr. Simmons, it's been advised that you want to enter a plea of guilty by way of an information, meaning you're going to waive the grand jury and plead guilty to the charge of the information brought by the prosecutor, a charge of possession of cocaine, a felony of the 5th degree. Is that what you want to do today?
Yes, sir, Your Honor.
Well, before I can accept your plea, I need to make sure you understand penalties that you face, the rights you're giving up, and what you're pleading guilty to. So I'm going to ask you a series of questions. If at any point you have any questions for me and need me to clarify anything, repeat anything, want to talk with your lawyer, make sure you let me know that, all right?
Yes, sir, Your Honor.
All right, let's get started then. How old are you, sir?
I'm 35 years old, sir.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir, I am, Your Honor.
Sorry?
Yes, sir, I am, Your Honor.
Prior to coming into court here today, have you any drugs or alcohol of any kind?
No, sir, Your Honor.
What about in the last 48 hours?
No, sir, Your Honor.
Not even prescribed medication? Nothing?
No, sir.
Now, did you receive a copy of this information that was filed by the prosecutor's office?
Yes, sir, I
Did you have a
Your
chance to look that over?
Yes, sir, I do, Your Honor.
Now, in that information, you are charged with one count, and what's alleged here, and what you're admitting to is on or about April 16th, 2025, in Willowick, Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount did not equal or exceed 5 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to here?
Yes, I do, Your Honor.
Any questions for that?
No, sir, Your Honor.
It's also alleged in a forfeiture specification that during the offense you possessed or had an interest in property considered to be contraband or an instrumentality. Contraband is property that's illegal, like drugs. That just by its nature, it's illegal. Instrumentality is some type of property that there may not be anything illegal about it, but it's being used in an illegal manner to facilitate a crime. You can't possess it for that purpose, and here it's alleged that all the drugs and instrumentalities, I'm assuming we're just talking about paraphernalia, no property like phones or cash or anything like that.
That's correct, Your Honor.
So the paraphernalia and the drugs themselves would be forfeited. Do you understand that? Meaning you lose any interest you have in that property. Do you understand that?
Yes, sir, Your Honor.
Any questions about it?
No, sir, Your Honor.
Well, then before I can accept your plea, I need to make sure you understand the rights you're giving up by pleading guilty. And you first of all have a right to have this case presented to a grand jury. Now, the case has been charged by way of an information. An information is a charge, what I just read to you, that's brought by the prosecutor's office without the case having previously been reviewed by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and meet privately. And they meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Everybody in Ohio accused of a felony, paying attention?
Yes, sir.
Everybody in Ohio accused of a felony has the right to have a grand jury independently review the evidence in the case and make a decision without the government being involved in that decision as to whether someone should be charged or not. And you have that right as well. But you can give up that right if you desire and go forward in the charge brought by the prosecutor, and your lawyer has indicated she believes that's what you want to do. Is that correct?
Yes, sir, Your Honor.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing, and I have in my possession here at this time a document, one page, called a waiver of indictment, which sets forth what I've just explained to you about the grand jury, and that you want to give that up. Before I can go any further, I need to have you make sure you understand this document, that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over this with your lawyer. Is that correct?
That's correct, Your Honor.
Ms. Novotny, is that accurate? Did you review this with your client?
Yes, Your Honor. Before the proceedings, when we went over that document, he understood the document, asked questions about the document, ultimately signed the document in front of myself and the prosecutor.
Is that correct, Mr. Simmons?
Yes, sir, Your
Do
Honor.
you understand it?
Yes, sir.
Any questions for me about what it says?
No, sir.
And did you sign it like your lawyer said?
Yes, sir, I did.
Very well, then I'll make this part of the record. At this point, I'm going to review with you all the other rights you're giving up by pleading guilty. And you first of all have a right to have a trial. And that could be, to me as a judge, where I would listen to the evidence and I'd make the decision whether you're guilty or not guilty of the charge. But you also have a constitutional right to a jury trial. And that would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision, which means all 12 of the jurors would have to agree together, one way or the other, whether you were guilty or not guilty of the charge. You understand that?
Yes, sir.
You understand by pleading guilty you're giving up your right to have a trial?
Yes, sir, Your Honor.
If we had a trial, the prosecutor here would be representing the state of Ohio. He would have what we refer to as the burden of proof. with him having the burden of proof, what that actually means is that it's his job, or he bears the responsibility or the obligation to prove you guilty before you could ever be found guilty. You're presumed innocent of this charge, and presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir, Your Honor.
Now, when we speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or part of the charge beyond any reasonable doubt before you could ever be found guilty. You understand that?
Yes, sir, Your Honor.
You understand by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
Now, in order to do that, or at least in order to try to do that, the prosecutor will bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer will be allowed to ask those same person's questions on your behalf. We call that cross-examination. She can ask him anything she wanted to within certain rules. Do you understand that?
Yes, sir, Your Honor, I do.
You understand by pleading guilty or giving up your right to cross-examine or confront those witnesses that will come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that, and you're not required to do that, but you have the right to do that if you want to. Do you understand that?
Yes, sir, Your Honor, I do.
And you further can request this court issue an order, and we call that order a subpoena. And what a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, sir, Your Honor, I do.
Do you realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Further understand that if you went to trial and you were found guilty, you'd have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir, Your Honor, I don't.
Do you understand them all?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
You understand your guilty plea is a complete admission of guilt, which means you're admitting to the facts being alleged by the prosecutor, and we're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir, I do.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes, sir, Your Honor, I do.
Well, not on a future day. You're going to be sentenced today in this case as well, apparently. As far as sentencing goes, you're pleading guilty to a felony of the 5th degree. That is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, sir, Your Honor, I do.
Are you on probation to any other courts right now?
Yes, sir.
I know you have the other charge pending in front of me. There's other charges pending too in other courts, apparently, right?
Michigan.
Michigan?
Yes, sir.
Well, in this case, I need to advise you that if we proceed to sentencing, you're going to be getting sentenced on this case as well as the other one. And as the judge, I'll have the discretion to impose a prison sentence in each case, and then I have the discretion to run those terms either concurrent or consecutive to each other. Concurrent means together, you serve them at the same time. Consecutive means one after the other. You serve the prison term in one case, complete it then the term in the other case. Do you understand the difference there?
Yes, sir, I do.
So with both cases, you're looking at possible 2 years in prison. Do you understand that?
Yes, sir.
Do you understand that? I also need to advise you that you're sent to prison. Upon your release from prison, you could be put on what's called post-release control. It's sometimes referred to as parole. It's a period of supervision you will be on after you serve the prison sentence, and in this case, it could be up to 2 years. You understand that?
Yes, sir.
And if you were on post-release control and ever violated any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, sir. I do.
Now, aside from the possible prison sentence, there's other sanctions that could be ordered. You could be fined, in this case, up to $2,500. You could be ordered to pay court costs. You can also be ordered to reimburse the county for any costs of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, sir.
You can also have your driver's license suspended for up to 5 years. You understand that?
Yes, sir.
You will also be ordered to forfeit any interest you have in any of the property they seized at the time of the sentencing. Do you understand that?
Yes, sir. I do.
Now, a few moments ago, I explained the possible prison sentence you face. I used possible because in this case, you are eligible for probation, what's called community control sanctions. Now, in order for that to happen, a pre-sentence investigation must be completed, and I've been advised that you're waiving a pre-sentence report in this case. Is that correct?
Yes, sir.
So you understand that I will not be able to impose probation in this case, since there's no pre-sentence report?
Yes, sir.
I can't hear you.
Yes, sir. I do.
Lastly, when we proceed to sentencing, you have the right at that time to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. She can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever the lawyers have to say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I don't have to go along and follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No, sir. I don't.
You understand all the possible consequences?
Yes, I do.
You still want to plead guilty?
Yes, sir. I do.
Have you had enough time to talk about this case with your lawyer and have her go over everything with you?
Yes, sir.
Has she or anyone made any promises to you about what's going to happen at sentencing, inducing you to plead guilty here?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering the plea freely and voluntarily? Are you entering your plea freely and voluntarily here today, or is anyone forcing you to do it?
No, sir.
So you're doing it voluntarily on your own, making your own choice?
Yes, sir.
All right, do you have any questions for me at this time regarding anything we've just talked about, concerning the rights you're giving up, the penalties you face, what you're pleading guilty to?
No, sir.
You need any more time to talk with your lawyer before we go forward with the plea?
Yes, sir.
Say no, sir, yes, sir.
Yes, sir. Yes, sir. Yes, sir. I do it.
You wanted to talk to her then? You need some time to talk to her? All right, go ahead. Just turn this on. he believes the evidence in this case would show if we had a trial. I want you to listen to him and what he says. I'll have some questions for you about that, all right?
Yes, sir, Your Honor.
Mr. Devanche.
Yes, thank you, Your Honor. Were this matter to go forward, this is the case ending in 524, Your Honor. The facts would show that by April 16th of this year, Willowbrook police officers had noticed that the defendant had an open warrant for his arrest. They were familiar with the defendant and his reported residence. On that day, the 16th, officers noticed a suspicious vehicle sitting in a driveway of a residence believed to be that of the defendant. This residence was in Lake County, Ohio. Officers approached the vehicle and noticed that the defendant was a front seat passenger. He was arrested. A search of his person yielded a couple of rolled up bills of U.S. currency that appeared to officers to be drug paraphernalia containing some drugs. The Lake County Crime Lab, in fact, confirmed that at least one of those bills contained cocaine, a Schedule II substance, in less than bulk amount, Your Honor. Thank you.
Mr. Simmons, were you able to hear what the prosecutor had to say regarding what he believes the evidence would show if we had a trial?
Yes, sir, Your Honor.
What, if anything, did you say about those facts he presented them? Are they true? Did you do what he said?
Yes, sir.
Very well, then regarding count one, charging you with possession of cocaine, felony of the 5th degree. What is your plea to that count?
Guilty, Your Honor.
And along with the forfeiture specification, guilty of that as well? Very well then. I have in my possession at this time a document. This is an additional document, 4-page document that sets forth everything I've just explained to you. It's called a written plea of guilty and judgment entry. Before I can accept your plea, I need to make sure you understand what this document says and that you sign it here in open court. My understanding is you had a chance to go over this document with your lawyer as well. Is that correct?
Yes, sir, Your Honor.
Ms. Novotny, is that accurate?
Yes, Your Honor. Before coming into proceedings today, we went over such document. He has questions about the document. His questions were answered about the document, and we signed such document in front of the prosecutor.
Is that correct, Mr. Simmons?
Yes, sir, Your Honor, it is.
Do you understand what the document says?
Yes, sir.
Do you have any questions for me?
No, sir, Your Honor.
And your lawyer said you signed it. Did you in fact sign it?
I did, in fact.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count one, possession of cocaine, a felony of the 5th degree in violation of 292511 of the revised code with the forfeiture specification. Ms. Novotny, you are waiving a pre-sentence report. I understand you're doing that based on the court's decision in the other case not to continue the sentencing. And since that's the court's ruling in that case, are you waiving your pre-sentence report in this case?
Yes, we are, Your Honor.
Then is there any reason not to proceed to sentencing? I know you already made your argument in regards to the renewing of the motion of continuance, and the court's denied that. Any other reason not to go forward with sentencing then?
Your Honor, we may proceed.
Anything you want? We're going to proceed to sentencing on both cases then, 25 CR 524 as well as 25 CR 77. What, if anything, would you like to say on behalf of your client?
Yes, Your Honor. We would like the court to consider any type of leniency in the minimum prison sentence available with respect to these two cases. I know my client understands that his addiction is a problem and subsequently entered and ultimately found himself with another case due to such addiction. He would like to, at some point, engage in some sort of treatment. He knows that his being incarcerated, he has a little taste of how that feels to be incarcerated, as well as being away from his family and the impact of him being away, how it has affected as a family. Your Honor, he is a stay-at-home father with 2 children. I know he's a stay-at-home dad. With that respect, while his fiance does work, he does take care of the children that they have at the residence. I know he informs me that him and his fiance is the only form of support for his family. There's no other support besides them. With that regard, Your Honor, to the start of his addiction, I guess you could say, Your Honor, it all stemmed from the loss of several family members that he endured. I know he was grieving a lot with that respect, and it kind of made him down a downward spiral, for lack of words. He knows he needs treatment. He knows he needs to help himself before he can help his family. He doesn't have any excuse for his actions with that. He does take full responsibility for the choices he has depictively caused. But he knows he needs help with trying to maintain sobriety and find some pathways to maintain a sober living. We're just asking for any leniency with regards to any type of prison sentence that will be imposed and the minimum sentence to be considered. Thank you.
Thank you. Mr. Simmons, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
I'm sorry, Your Honor.
Is there anything you would like to say at this time on behalf of yourself at sentencing?
I just want to apologize for the inconvenience, Your Honor. I need help. If you have,
I'm sorry?
I said I need help, Your Honor, and if you could have some leniency on my sentencing, I would greatly appreciate it. I just want to get back to my family.
Ms. Navani, anything else?
No, Your Honor.
Mr. Devanshi for the state?
Yes, thank you, Your Honor. Because the defendant does not appear able or willing to obey explicit directives, he has flouted bond and violated probation in the past. For these reasons, we would trust the court's discretion to fashion an appropriate prison term, Your Honor. Thank you.
Well, this court has considered the particular facts and circumstances of the offenses involved in each of these two cases and do not have a pre-sentence investigation to review, as the defendant failed to cooperate with probation and didn't show up at the probation department on 2 separate occasions for the preparation of that report. But I have been presented with a criminal history, giving a little bit of background. I consider what's been said here in court, and it's all considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, there's nothing indicating it's more or less serious than normal for either case. Recidivism factors, the court will note that both of these cases were committed when the defendant was on probation to Michigan. He's been on probation since October of 2014. A warrant was issued for a probation violation in November of 18. It's been outstanding ever since that time, but he committed these two offenses while on probation with that warrant outstanding. He committed the latter case in 25 CR 524, the offense in that case, while he was on bond awaiting sentencing to this court. There's also another warrant out of Willoughby for a traffic offense for failing to appear for a hearing. Or was that one, or that one was resolved? Apparently that looks like that was resolved. So the only warrant out for him is for Michigan right now. It's been out for him though for 11 years. From the recidivism factors, again, the defendant does have a prior criminal history. He's not responded favorably in the past to previously imposed sanctions. Violated his bond by testing positive in the 77 case. At this point, there's no PSR. The court does not have authority to grant, place the defendant on community control sanctions. Prison's consistent with the purposes and principles of sentencing, and the defendant's not amenable to community control sanctions if he can't comply with bond conditions. Therefore, it will be the sentence of this court that in each case, defendants serve a term in prison of 7 months. I'll run those cases concurrent with each other. In 25 CR 77, he has 22 days of credit. In 25 CR, he has 25 CR 524, he has 20 days of credit. I need to advise you in each case, you may be placed on post-release control upon your release from prison. If you are and you violate any of those conditions, the parole authority can send you back to prison as punishment for violating the rules for another 3.5 months, the maximum being 50% of what I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in program of shock incarceration, intensive prison program, transfer to transitional control. I'll order the forfeiture of the contraband and instrumentality set forth in the specifications. The defendant's order to pay all costs. Is there anything else for the record, Mr. Tavanchi, for either case?
I believe I have it, Your Honor. Thank you.
Mr.
No,
Novotny?
thank you.
Sorry?
No, thank you.
Mr. Novotny?
No, Your Honor, thank you.
All right.
All rise.
We're hearing case caption State of Ohio versus Jessica Glenn, case number 24CR001397. We were last here on March 26th, at which time the defendant entered a written and oral plea of guilty to count 2 in this matter, that being failure to comply with the order signal of a police officer, felony of the 4th degree, in violation of 2921.331B. At that time, the case was then referred for a pre-sentence report and investigation and a drug and alcohol evaluation. Those have been completed. We are here today for purposes of sentencing, and the defendant is present with her counsel, Mr. Michael Goldberg.
Mr. Goldberg, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
I would, Your Honor. Thank you. May it please the court. So I've read the pre-sentence investigation report. I appreciate the court making it available to me. I think that report checks many boxes that I personally don't usually see in a failure to comply case. Those being lack of any serious prior criminal history. I understand that there's a bad driving record. Lack of there being some type of crime that was committed, other than we can infer maybe an OVI here, but not running from the police to hide the fact that they have drugs or a firearm in the car.
How do we know that?
Well, I'm pretty certain that's the case, Your Honor. Obviously, my client went to her house when she was approached by the police. When they came, her husband let them in. She went with them. She admitted that she was driving the car. So you're right, I don't know that, but I feel like that's the case. I would say that her acceptance of responsibility is remarkable, and a lot of times I see clients saying, I'm sorry that I was in the wrong place at the wrong time. I think she's really owning what she did here. She's embarrassed about not only the circumstances of the offense, but also how it makes her kids look at her. I think that she has shown herself to be able to stop drinking. She's tested negative the 2 times she was tested. She was on GPS for a number of months, complete compliance. She actually did 5 days of jail time, so she was arrested. I believe it was a Thursday. If your record shows something different, Your Honor, yours are going to be right. But I believe she didn't get out of jail until Tuesday.
Let's check on the PSR showed 4 days. Let's just make sure.
Something like that. So she was in jail for an extended arrest period of time. So Your Honor, we were going to suggest to the court that a community control sanction in the community would be sufficient but not greater than necessary to serve the principles, purposes of sentencing under 29, 11, 12, and 13. We know she's going to get a license suspension. We know she's going to have a felony on her record for the rest of her life. She has a really good job right now. I don't know if she can keep it. She's going to try. Driving would be an essential part of it. But at the time that this happened, Your Honor, she was being a server or bartender at a bar. And obviously, that's not a good place for her to be if she can't govern herself, and she couldn't this night. But it does seem to be an aberration in her conduct. So she went out and found a job where she could do the most good, and that is working in a group home as a direct care provider. She loves it. She's done that for a number of months, and she's been promoted to a manager of a house, and she's going to do everything she can to keep this job. It may be impossible, but she would like to try to keep it. She agrees with the recommendations of the alcohol drug assessment. She has no problem following all of those recommendations. She would, in fact, follow any recommendations this court were to impose as a condition of community control. And I'll tell you this, Judge, she does know that most people convicted of failure to comply, not only in Lake County, but in most places, go to jail. That is a general thing. Not everybody, but most people. And I've explained that to her. I just think her background, the circumstances of this particular offense, if you look at the seriousness factors, I mean, you know, there aren't any more serious factors. And then as far as the less serious factors, she she didn't expect to cause harm, but I think that may have been a function of her condition at the time. But I'll say that as far as the recidivism goes, she definitely shows genuine remorse, and she definitely admits she has a problem and is willing to work to try to address that. And I know that the court has to review the factors in a failure to comply case. This is a case where it didn't happen on city streets. It was on the freeway. She was going extremely fast. She did have her lights off, but I don't believe her lights being off was intentional at all. And I think she forgot to put her lights on, and she wasn't trying to evade the police by turning her lights off. She gets off the freeway. At that point, she's no longer driving in that manner, and she goes home. Once the police come, she takes responsibility for what she did. She's not proud of it at all. She's very, very ashamed. But, Your Honor, I think she's been through punishment. She's going to continue to go through punishment, and she doesn't necessarily need to go to the county jail for jail treatment to be fully and appropriately punished. And the court always reserves 18 months if she doesn't get it this time, which I really think she does get it, Your Honor. And everything I see in both of these reports tells me she does. So I'd ask you to consider that, Your Honor. Thank you.
Thank you. Ms. Glenn, you have the right to address this court before you're sentenced. You can say anything you'd like. Is there anything you want to say at this time?
Yes. I'm very ashamed. I lost respect for my children, and I'll never get that back. I was working at the bar for 4 years. I don't really drink. That day, my husband, he was in the hospital. He has a condition with his intestines. My husband's older, and my son was acting out, and I drank, and I just got out of control, and I quit there, and I got a job in furthering my nursing, because I have a medical assisting license and phlebotomy license, and they already promoted me to manager, and the children there would be really sad if I, won't be able to work there because driving is a necessity, and I'm glad I didn't hurt anybody. I'm glad I didn't hurt myself. And I'm sorry. I just don't want to go to jail. And I'm sorry.
Thank you, Ms. Glenn. Mr. Goldberg, anything else you want the court to consider?
No, Your Honor, between what I said and what Ms. Glenn said, I think that's sufficient.
Thank you. The State of Ohio?
Thank you, Your Honor. Your Honor, as indicated in Chambers Estate, is not opposed to community control, but with jail time and jail treatment program. This is a situation where it's a Friday night, she's driving without her headlights at 100 miles an hour, and the officer noted that she made multiple marked lane violations. She was traveling in and out of lanes without signals. She was abruptly switching lanes in front of other vehicles, so clearly there was some serious risk, not only because of her driving, but also having her lights off. My guess is that it's probably because she had been drinking and she was drunk and she didn't remember to put them on, which makes it even worse. She fled so that she could try to get to her house. When the officers got there, she smelled like alcohol, was slurring her words, had red glassy eyes, she was stumbling, and she could barely stand on her own. And then during the transport, she's screaming and yelling profanities in the rear of the cruiser. So in terms of looking at her behavior, when the officer then came out to try and get her out of the cruiser, she had thrown up all over the back of it and indicated that she had been coming from some bar in Euclid. So looking at that and looking at what she did here, it is warranted that there is jail time and that there are consequences in jail treatment. I understand that her OVIs were quite some time ago, but clearly alcohol is an issue, and jail treatment would be a good way to address that. while providing consequences as well. We'd also ask for the requisite driver's license suspension as well. Thank you.
This court has reviewed the pre-sentence report and investigation that was completed. Drug and alcohol evaluation. And considered the facts and circumstances of the offense involved, the nature of the offense involved. I've considered everything that's been said here today by Mr. Goldberg, the defendant herself, the prosecutor, the recommendations. All of this is considered in light of the purposes and principles of felony sentencing set forth in 29-2911 of the revised code. So the factors in 29-2912 indicating the conduct is more serious. There are factors indicating it's more serious. The defendant was very, very drunk while she was doing this. In fact, again, as alluded to by the prosecutor, when she was ultimately arrested, she could barely stand, stumbling. She fell asleep on the bench at the jail. She threw up in the back seat of the car. Extremely verbally abusive to the officers. That all shows the extent of her intoxication when she was operating this vehicle. So that makes it more serious. And the fact that she's driving without her lights on makes it more serious. She's driving over 100 miles an hour makes it more serious. Nothing makes it less serious. As for recidivism factors, defendant has just 2 prior OBIs from some time ago. 2004 to 2008 in Florida, both of those convictions. Aside from that, got a bad driving record, but no other convictions, criminal convictions. Certainly an alcohol problem that relates to this offense, and I don't know if the defendant gets it. She claims she hasn't used since then. We don't know that. We don't test for the alcohol. She hasn't used any drugs. But she's never gotten any alcohol treatment, drug treatment. She's been using marijuana daily for 29 years. She says she started using marijuana when she was 13, and she's used it every day up until the time of this offense. And she's never gotten treatment. In fact, she wants to continue smoking it. Obviously, an alcohol problem also. And even with the 2 prior DUIs some time ago, she's claimed that she's never had treatment. As for factors indicating recidivism is less likely, the court finds the defendant has led a law-abiding life, significant number of years, basically her entire life, aside from the OBIs that she had. And there appears to be genuine remorse. She's remorseful here today. She was remorseful at the plea. She seems like she cooperated with, was very forthcoming with the probation when she met with them. Those are all factors indicating recidivism is less likely. There are no factors present under 29-2913B1. Court finds at this time that prison would not be consistent with the purposes and principles of sentencing, and the defendant is amenable to an available community control sanction. So I'm going to place the defendant on community control sanctions for a period of 2 years. But there is a need for consequences with this type of conduct. This is a bad fleeing and looting. Being drunk like you were, lights off, 100 miles an hour. That's bad. And consequences are deserved. Plus, there's some treatment that needs to be dealt with. You've never had treatment, and you've got a significant issue. So I'm going to order the defendant its conditions of her community control sanction to serve 60 days in Lake County Jail. She has credit for 4 days she's already served. I'm going to order her to enter and successfully complete the jail treatment program during the last 30 days and follow all aftercare recommendations. That's going to include at least 3 AA meetings a week. You're not to use any drugs or alcohol. That includes no marijuana. You're not to use any marijuana, even pursuant to any prescription, no marijuana at all. Submit random urine screens. It has to be negative. Positive screen will be a violation. You're to obtain and maintain full-time employment, though you're not permitted to work at any type of bars where you're serving alcohol. You have one doctor and one dentist that you can get prescriptions from. If you have a specialist, that's fine as well. But those are the only doctors that can give you prescriptions. Let me provide those names of probation so they know who they are. One pharmacy where you get prescriptions filled, they need to know where that is as well. You need to sign whatever releases they need to contact those folks if necessary. To obtain a mental health evaluation, follow whatever, if any, recommendations are made for any type of counseling or treatment if they feel that's necessary. If not, then you don't need to do that. There are court costs and supervision fees. There's a mandatory license suspension of at least 3 years up to lifetime revocation. The court will suspend your license for the minimum 3 years. I want you to take all your medications as prescribed. Mainly concerning the prescription you have for Miss Joy King. She's a psychiatrist. Continue your psychiatric counseling with her as well. Derek, anything else I should be considering? Ms. Glenn, you understand all the conditions of your community control sanctions?
Yes, Your
Any
Honor.
questions for me?
Did he say 60 days in jail? 56.
Any questions?
No.
I need to advise you, if you fail to comply with any of these conditions and the rules of probation, if you leave Ohio without permission from this court, or if you commit another offense while on community control, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it would be 18 months in prison, which would be consecutive to any other sentence you may be serving at that time for something else, or a new case that you may, if there is a new case. I will dismiss count 1 as agreed to, and I will release the defendant's bond at this time. Ms. Linden, is there anything else for the record?
No, Your Honor, thank you.
Mr. Goldberg?
None at this time, Your Honor.
Thank you.